Immigration is as front and centre in both the news and people's minds at the moment as it's ever been. But while there's a lot more information out there about immigration, there's still a lot of really common misconceptions. And that can be really important, both in terms of people making really basic errors when they're applying under the immigration rules, but it also means that the debate about immigration that we see in the public is often misinformed. It's therefore really important that we correct these errors, both to help people and stop them from making these mistakes in their applications, but also to ensure that we're having a more informed debate as a public about immigration going forwards. So one really common misconception is the idea that if you are married to or in a long-term relationship with a British citizen, you can just live in the UK automatically. And that's a mistake that's often made particularly by what we would call non-visa nationals, and that's people who don't require a visa to travel freely to and from the UK. Unfortunately, being in a relationship with or married to a British citizen is not enough in and of itself to enable you to actually live in the UK. You do need to obtain a visa to permit you to live here. And that visa can be quite difficult to get. There's a series of very strict requirements that have to be satisfied. The most pressing of those is often the financial requirement. Since 2012, that's been a really rigid set of requirements that have to be satisfied. The applicant has to show that there will be an income of at least £18,600 or that savings are held for a period of 6 months of at least £62,500. Now, those levels can be considerably more than a lot of people are able to actually meet, but even where people do have relative income or significant savings, they still can't often meet the very strict documentary requirements in order to come in as a spouse or partner. And what that has meant is that over the last few years, there have been estimates of thousands of families, including children, who've been separated due to the application of these immigration rules. Now, it is true that in theory, a person can be admitted to the UK for up to 6 months at a time as a visitor. However, unfortunately, if you turn up at the border and say that you're looking to come to the UK for 6 months, you're likely to face quite extensive questioning and you may not actually be admitted for that period. Visitors generally are supposed to come to the UK to see tourist sites, potentially to visit family and friends, take photographs, go home. 6 months is a very long time for someone to spend in the UK doing that under normal circumstances. They wouldn't be able to work, they'd have to support themselves over that period of time. Similarly, people spending less time in the UK but over a series of successive visits may also find difficulty in the long term. One of the requirements of the immigration rules as it pertains to visitors is that you aren't supposed to actually base yourself in the UK as a visitor. So if you are coming back and forth from the UK a number of times, that too could raise questions and may ultimately end with someone being refused entry at the border. People sometimes think that once they're here as a visitor, they'll actually be able to make their application to remain in the UK as a partner once they learn that they do in fact need a visa in order to live here. Unfortunately, the general rule is that these applications have to be made from overseas and the applicant has to apply for what is known as entry clearance. The difficulty is that those applications can then take quite a long time to be processed. Standard processing times for a settlement application can be up to 12 weeks. It's therefore really important that people prepare not only to ensure that they can meet the requirements of the immigration rules, but also that they allow enough time for any application to be processed and for them to actually travel to the UK within the time frame that they were hoping to actually be here. One issue that we often see is that people think that because the Home Office is connected to the government, they will be able to undertake checks with other government bodies, for example, HMRC. Unfortunately, that's not actually the way the application process works. An applicant is very much expected to provide all the documentation in support of any point they're trying to show as part of their application. The only real time that we see checks being made, for example, with HMRC, is if the Home Office is looking for a way to refuse an application. It may be, for example, that if someone has claimed a certain level of income and that is contrary to the income they've declared to HMRC, they may make checks at that point in order to in fact refuse an application. It is very rare that they will make those checks in order to help somebody to meet the requirements of the immigration rules. Another issue that's increasingly common in the modern digital world is that people receive a lot of the documents that they need to rely on online. And the Home Office won't, as a general rule, accept printouts of those documents in place of in inverted commas, originals. This is a particular issue with bank statements. If an applicant has online banking, then it's really important that they get the bank to either send them original statements on their original headed paper, that they go into a branch and get every page of their bank statement stamped, or they get a letter from the bank on original headed paper confirming the authenticity of those statements. Over the last few years, we've seen a real reduction in the ability of applicants to actually appeal decisions when they've been refused. The only real basis for most people now to appeal a decision is where human rights are engaged. We've also seen that the Home Office has sought to make it very difficult for people to exercise a right of appeal from within the UK. This means that people often have to actually leave the UK first before they can appeal a decision. This can result in really lengthy delays and also separation between family members. Appeals can take anywhere from 12 to 24 months to be concluded, which can be a really long time to be separated from a loved one. In practice, therefore, it's often more sensible to make a fresh application in order to correct any errors and to deal with any issues that have been raised in a refusal decision. It is, however, very frustrating because we do see that where a decision is appealed, around 50% are in fact reversed by the tribunal on appeal because of errors made by the Home Office when considering the application.